Zwarte and another, and Kanhai and another.
Now, let's just work out who we've got where. Yes. Mr. Baharilal, good afternoon.
Good afternoon, my lords
and
ladies.
You're here with Ms. Sutcliffe and Mr. Hitchins.
That's correct.
You're here in person.
Yes.
Mrs. Seaber-and-Sweet, good morning.
Yes, sir.
You're
I am
here for the wife, as I will call her, and I believe you're being supported by Mrs. Perryman Pollard. Is that correct?
That is so, my lord.
Good. Obviously, we'll be hearing from Mr. Baharilal first. I don't expect that you will need to. I don't expect there will be any need for you to interrupt him to any significant extent, but if there was anything that, while he was on his feet, you wanted to say, please raise your arm. We will notice that, and we will turn to you and find out what the problem is. But at the moment, are you confirming that you can hear what is being said in this courtroom?
Yes, my Lord Wilson, we can hear what is being said.
I do hope there will not be difficulty in hearing what you, and if Mrs. Perryman Pollard is going to follow, what she says to us, and obviously to the appellant side. We have been warned that, disappointingly, there are some difficulties in the way of hearing you this afternoon, and we will have to see how it goes. But apparently, for example, the room in which you are sitting has been moved from the room in which the test was made previously. And apparently there have been one or two other changes which may make it, to some extent, difficult for us to hear. But we must hear every word that you say, and let's see how we go. Is that acceptable to you?
Certainly, my Lord, except that this is indeed the same room.
It is the same room. Well, then I misunderstood what I was told. So let's see how we go. And Mr. Baharilal, please address the board.
I'm grateful. My Lord, in opening this appeal, the essential arguments are essentially threefold. The first is that the Court of Appeal could not order a stay of the appellant's orders for sale because those orders were made only in what we've classed as the debt proceedings, which were not appealed. The family proceedings, in which various orders were made, did not include any orders for sale in favour of the appellants.
Mr. Baharilal,
yes.
I think you should speak up.
Very well.
I haven't had indication from Mrs. Seaber-and-Sweet that she's had trouble hearing you, but you were speaking quite quietly.
Very well.
And I think you ought to speak more loudly and more slowly, if you don't mind my saying.
No, not at all. I'm happy to do that.
Thank you.
The first argument, my lords, is that the Court of Appeal could not order a stay of the appellant's orders for sale because those orders were made in the debt proceedings only, which were not appealed, and as we appear before the board today, remain unappealed. And also because in the family proceedings, which have been appealed by the respondent, no orders for sale in favour of the appellants were ever made. Secondly, the Remedies of Creditors Act provides a comprehensive code that would have allowed the respondent, if she wished, to appeal to the Court of Appeal, challenging the making of the orders for sale under that Act, with the appellants being able to meet those arguments, such as they may be, including any application for a stay of the orders for sale. And we say that as a consequence, absent any appeal in the debt proceedings in which the orders for sale were made, Mr. Kanhai's beneficial interest in the property is the date of registration of the judgment under the Act, because the separate family proceedings to which the appellants are not a party cannot, in these circumstances where the orders for sale are not appealed, affect those orders for sale. we adopt and pray and aid our case for the appellant, and I'm hoping
Did you say you had 3 points?
Yes, sorry, that I should have said. The third point is as a consequence.
I see. Oh,
that is the effect.
Oh, I see.
Forgive me, but that's essentially the third point, that absent an appeal of the orders for sale, you simply cannot stay those orders in this way. And as far as the moving into the appeal itself, we adopt and pray and aid the case for the appellants, and essentially we draw the board's attention to one key feature in the record. The board will have seen, if I can take you to it straight away, page 5, just as an example.
Yes.
That both companies issued proceedings in the civil courts, and that's designated by the top left-hand claim number entitling CV.
Yes.
And it's the same if you turn to page 8, different number, but again issued in the civil proceedings. Now those numbers, my lord, carry through, except that in the family proceedings, and again to give you the best example, if you turn to page 138, this is the without notice application for the stay.
Yes.
You will see the top left-hand corner, the family proceedings designated number FH.
Yes.
And what we say, my lords, is that it is very clear, and we say shouldn't be disputed, that the proceedings were kept separate, deliberately so, because the judge, Madam Justice Ramkerry Singh, refused an application for joinder, as we understand it, and secondly, did not want the creditors getting involved in the family proceedings. And so, because those proceedings were separate...
I wonder how interested we're going to be, Mr. Bahari Lal, in the argument that particular orders were made in Proceedings A rather than Proceedings B.
Yes, well,
We'll have to judge how far to press that sort of argument.
My lord, I can indicate that the intention is only to address that which the appellants can address, which is essentially the orders made that they are trying to meet, which is the stay. We can't address anything in the family proceedings because, as the board knows, when the record is settled, all of the documents for both parties are agreed, placed into the record, and many of the documents which are referred to in the case for the respondent we've not seen, and that is a difficulty. So I'm not intending to address any of that, but what I can indicate is that the distinction...
You've got the record that we've got.
Yes.
We've all got the same record.
We all have the same record.
I didn't collect from the respondent's case that they were referring to many documents other than those which we had.
Well, there are various, my lord, there are various references, for example, on page 2 and on page 13. Forgive me, this is the electronic bundle 416 and 427, where there are various references to documents which, as I say, we've not seen, but that was what that referred to.
Very well.
Shortly. If I can take you straight away, please, to the orders for sale, and this is... my place. If I can invite you to turn to page 130 of the record.
Yes.
This is the order for sale in relation to Zwarte Band's claim.
Before you move on to that,
Sorry.
taking up the point you just made,
Yes.
my paper bundle ends at 379. But the electronic version goes on and includes 416. There's a gap between the end of the paper bundle and the authorities bundle. Have I got an extra bundle somewhere?
You should have, my lords
Right.
and my ladies, the record, the Statement of Facts and Issues bundle, which should begin at 380.
Oh, right. Okay, that's fine. Oh, it's because I pulled it apart.
Not at all, yeah.
Thank you.
It's, That's probably the gap.
Yeah.
And the orders for sale, page 130 and page 133, are the orders made in the civil proceedings only. You can see that the top left-hand corner, same designated civil case number.
The order recites that the matter comes on for hearing in the family court.
It does.
Is that just a location?
Absolutely. That's precisely because the orders having been remitted to this judge, it comes on during those proceedings, but she treated them as separate because, as I say, the appellants were not party to the family proceedings, but it is simply a matter of location. That is quite right. Be that as it may, what we say, my lords, is that when you actually...
You say it's just a matter of location.
Yes.
But the wording reads, upon this matter coming on for hearing in the family court in FH, and then there's the number
Yes.
of the family
Yes.
proceedings.
That is correct. It has been remitted to the family court, but the proceedings were not joined. Perhaps that's a better way of phrasing it. But it was not part of the family proceedings. And as Ramkari Singh's judgment makes clear, she says several times that she actually kept the proceedings separate.
And it
I mean,
appears,
I'm so sorry, after you, please.
I was just going to say, it appears that that happened because of an order made in a civil appeal.
That's correct.
Do we have that order?
You
We
do.
do. 128, 129. 129, Mr. Bahari
Yes,
Lal.
I've got it. It's
We've got
128,
the-
129.
We've got the Court of Appeal on 27 January 2014,
Yes.
setting aside Mr. Justice C. Prasad's order and remitting the application of your clients for hearing before the High Court to be heard together with the ancillary relief proceedings now pending before the
Yes.
Family Court. Wasn't that quite a sensible order for the Court of Appeal to have made?
My lord, they made the order. We don't argue against it. That was where the hearing was held, and we can see the logic, if you like,
Yes.
of the same judge who needs to be familiar with all proceedings having this matter before it. And in fact, Justice Ramkari Singh says that she gained great insight in having had sight of the various civil proceedings. In relation to that order, what we say then went wrong, if you now turn, please, to page 136, is that the respondent then lodged an appeal in the family proceedings against her husband. And if you look at page 137, you can see there who was served with this notice, filed with the court and to Mr. Ronald Dowlatt, who was the attorney acting for Mr. Kanhai. And if you turn to page 140, the without notice application, again, you see the same references as to where it was filed and on whom it was served.
Correct me if I'm wrong,
Yes.
there is a dispute between you and the wife as to whether you were actually served
There is, and this is
with
why...
this, with notice of this without notice
Yes.
application.
Yes.
You are firm that you weren't served. The wife says that you were. At all events, correct me if I'm wrong, you didn't turn up on the day.
We were not there at the Chamber Court, and on discovery of the order, they did appear at the full court.
They did.
When they made on application.
That's
On
as we understood it.
Yes. Now, my lord, can I deal straight away with the assertion that the appellants were served with the stay? We've indicated that it is not correct. And the reason I drew the board's attention to those particular references is it shows who was served. It was the same submission that was made before the Court of Appeal, that the appellants did not have sight of it.
Well, it's all water under the bridge.
It is, but I simply make that point, and I'm not going to
Okay.
take it any further. As far as the judgments are concerned, what we say essentially is this. If the respondent wished to appeal the orders for sale, she had a remedy available under the Remedies of Creditors Act, a swift appeal to the Court of Appeal, because under Section 64 of the Act, appeals of any order made on a summons for sale is treated as interlocutory. And if I could invite the Board's attention to the bundle of authorities. And it's page 64. Sorry, forgive me, page 462, section 64.
Oh,
462.
yes.
And I'm not going to read it out. I know the Board will be familiar with it, but essentially it treats appeals, any order made by a judge on a summons for sale, as interlocutory orders. Because of that, forgive me, if the Board goes to page 475 of the bundle, and it's turned to page 477, which is the actual extract. Under the civil procedure rules, an interlocutory order would be treated as a procedural appeal. And then if you turn to page 478, Rule 64.5 indicates that in the case of a procedural appeal, it must be appealed within 7 days of the decision being made. So what we say, my lords, my ladies, is that
So what was that last reference?
the 478,
478 is the 7
Rule
day limit.
64.5,
Thank you.
paragraph A,
Thank you.
within 7 days. And what we
The
say,
wife says, I didn't think I needed to appeal because I'd got a stay.
well, let me deal with the stay.
Do.
There was no stay. Can I take you, please, to the, just bear with me, to the record again, and it's page 296 of the record. This is the transcript of the Court of Appeal, and it's lines, forgive me, transcript 200, page 296 of the record, and it's lines 21 to 25 initially, and this is it says Miss Perryman Jones, but I believe it's Mrs. Perryman Pollard. Line 21, so we did not appeal that order because the family order had been stayed until the decision of the family court proceedings, so there was no need to appeal the order. And if I can take the Board to line 42, Justice of Appeal Jones, having looked at the order, and we say that it is clear on the face of the order, it wasn't actually a stay. The judge just said it was not to be published before 5th of June. And Mrs. Perryman Pollard, before the 5th, reason for that is we were supposed to have a decision on that date. It wasn't a stay, that is correct. So that point had actually been conceded before the Court of Appeal. And we say that that must be right, because when you actually look at the order, which is
(130) possibly?
130,
No.
it's actually when you actually look at the order, and they're identical in this respect, it's order number, forgive me, paragraph number 4 on 131. And what the judge has done is simply set the timetable for the purposes of the sale of the property, not to be published before the 5th of June. And so the board has the reference, page 134, is in identical terms for the second appellant, Crown Band and Service.
Well, the wife would say, whether it was a stay, perhaps it wasn't. The fact is that nothing was going to happen until the 5th of June, when I was expecting my ancillary relief determination. So these are they small points that you're making?
They are small points, but what the big point comes to this. We say that an order for sale of a matrimonial home is a major event. Must be, and we accept that. We also accept that the respondent would have been extremely concerned about that. But once an order for sale is made, my lord, what we say is that if you have a remedy available for challenging it, which you do under the Remedies of Creditors Act, surely the urgency is on the date the order for sale is made, and particularly where you have a short period to appeal. And that being so, the urgency, we say, was on the 17th of March 2015, when the order for sale was made. She could have made it within time, on notice, so that the appellants could address it. But the unsatisfactory position that we find ourselves in is that the appellants have orders for sale which are valid, which have not been appealed, and yet they're not permitted to proceed with it. It's not even been stayed in the proceedings in which they were made. And the question arises, well, my lord, can the Court of Appeal have made the order it did in the family proceedings without there even being an appeal in the debt proceedings? And we say that, how attractive the argument is, I don't know, but could I take you to the law in relation to stays? That may be of greater assistance.
Of course.
And the law is taken, my lords, from the case of National Stadium, which is the authorities bundle, E-bundle 532.
Yes.
And it's can take you straight away to 535, which is the relevant reference. And if I can invite the attention of the board to paragraph 4, and it's the same rule, we've not replicated it in the bundle of authorities, provides that a single judge may make an order for a stay of execution of any judgment or order against which an appeal has been made, pending the determination of the appeal. And it's those words, against which an appeal has been made, that we say are operative here. And because of that, whether the argument made is an attractive one, both the civil proceedings rules, coupled with the Remedies of Creditors Act, say if you're going to appeal the orders for sale, you do so in the proceedings in which they're made. It's a very odd situation to have a stay being granted in the family proceedings where, in fact, those orders were not made. Now, I know that one of the points being made, and my Lord Wilson may have this in mind, that the respondent is saying, well, look, I'm appealing pretty much everything, including those orders for sale. Can I invite you, please, to look at the notice of appeal that she lodged in the family proceedings? And this is at page 372. And it's take you to section 2 of the notice of appeal, the parts of the decision appealed against on page 373. This sets out what her appeal is about. And if you glance down Roman numeral 1 to 8, going over to the next page, it doesn't include any appeal against the orders for sale made in favour of the appellants. And that must...
But she does mention it in the ground.
She does mention it in the grounds. She says a ground as to why she... and this is, my lady's quite right, 376 Roman numeral 5. She's saying that the judge erred in ordering the sale in the civil proceedings and then also failing to stay the orders. But in terms of the actual parts of the decision which are appealed, the judgment, the order, if you like, doesn't include any orders for sale. And of course, all the respondent has done, if I can take you please to the judgment of Ram Keri Singh, it's a couple of pages back, page 369 to 370. She has effectively challenged each of the orders and declarations in paragraph 51 of Justice Ram Keri Singh's judgment. And so we say that the Court of Appeal, with this notice of appeal in front of it, with an application for a stay of the orders for sale, would be entitled to ask, and we say should have asked, hang on, what is actually before this court? What is what is being appealed, and what are you seeking to attach the stay to?
Mr. Beharla, I'm sure your understanding of the CPR in Trinidad and Tobago is much better than mine. But is CPR Rule 64.181b the only power which the court has to order a stay?
Well, it's the part which we rely on for the purposes of the case law, my lord.
Well, I can understand that, but for your submission to carry force, it would have to be, wouldn't it, that there's nothing else in the CPR which would have authorised the Court of Appeal to order a stay?
Well, one part of
what
it,
about
yes.
a stay of execution, for example?
What I was going to say, my lord, is that in relation to how the Court of Appeal reasoned this, they didn't say what power they were acting under. They didn't say the basis upon which they were granting the stay. They simply said the wife would be prejudiced. And so they haven't identified any other power that they were purporting to act under the civil proceedings rules, to say that they could make this order, and didn't ask the question that I've asked, I hope fairly, well, what is actually the appeal before us and what is the stay being attached to? And when you look at the documentation that is in the record, what is clear, we say, is that the notice of appeal and the application for a stay both relate to the family proceedings in which no order for sale has been made. And that if that is right, and we say it is, then the question arises, well, what is the basis upon which the Court of Appeal purported to act? And can I invite, in relation to my Lord Briggs question, the record at page 302. And at 302, this is the short extemporary judgment by Justice of Appeal Mendonça, line 18, going over the page to line 11.
Stay of execution.
Where the Court of Appeal dismissed the appellant's application to set aside the stay with costs, and doesn't identify the basis upon which the court is acting, doesn't deal with the submission that was made in the Court of Appeal, the same submission I've made to the board, that here's a notice of appeal, it's in these proceedings, here's a stay, it's in these proceedings, but doesn't include an order for sale. And that the wife can, if she wished, appeal in, we say, the correct way. So,
Mr. Baharila, we've spent half an hour you dancing very nimbly and attractively around all these orders,
yes,
looking at the headings, saying that's quite wrong, how could that have been made in those proceedings? Isn't there a much more important fundamental point about the interlocking of these civil proceedings and how they ended up with the family proceedings? Is it possible for us to create a wall between the two proceedings?
well, my lord, in answer to the question, we're inviting the board to recognise the difference in jurisdiction. We are not saying that the wife could not have appealed. What we are saying is that the way in which this was done, jurisdictionally, in law, is wrong. If the board accepts that submission, then it must follow that the Court of Appeal was not entitled to grant the stay. I mean, that's really what it comes to. But dealing with the interlocking considerations my Lord Wilson has made, the judgment of Justice Ramkari Singh deals, we say, with all of this quite fully. And if I could invite the board's attention to the judgment, just for a moment. It begins at page 226 of the record. Sorry.
Mr. Maharimal, this is one of those bundles which contains 2 copies of a relevant document. I have annotated up the copy of the judgment at page 169.
Yes.
So would you mind using paragraph numbers?
I don't have a difficulty with that, my lord. Paragraph 1 is really the summary of the judgment, that both parties were fully entitled to ancillary relief. Paragraph 3, that there was nothing complicated, particularly about this case, save that the summonses for sale and the several other default judgments filed by the creditors was what she felt required her to give a written judgment in these proceedings. Paragraph 11 she's taken into account the Court of Appeal's decision to send the summonses for sale to this court, which she says gave her some perspective on the performance of the company, which she said was still successful. And just so that the board has the reference, paragraphs 3 to 6 of the judgment generally show that the judge was fully aware of the civil judgments, but where she explains, particularly in paragraph 6, why she treated the 2 proceedings as separate. And I hope this deals to some extent to my Lord Wilson's question. I deliberately treated the 2 sets of proceedings separately, and in the application under consideration, I've confined the division of assets as between the parties only. My reasons for doing so are outlined below.
But could she treat the 2 sets of proceedings separately? And if the husband's interest in the matrimonial home had been charged 3 years previously, surely in the identification of the marital assets, that had to be taken into account.
Absolutely. Of course it
But
has.
did she take it into account?
She did. And what we say is, being aware of both sets of proceedings, one of the things that she was concerned about, well, she had a number of concerns. Paragraph 4, the very long delay that had occurred in the family proceedings and the resulting unfairness to the appellants. And paragraph 10, recognition that both parties played vital roles in the development of the property. This is the matrimonial property. And then, if I can, I'll go through this quite quickly, really just to give the board the references. Paragraph 26, which deals with the default judgments and the orders for sale. And paragraph 26 does bear mention because the judge refers there to 11 default judgments taken up against both Mr. and Mrs. Kanhai. And one of the themes throughout the judgment of Justice Ramkari Singh is the concern that if she took into account all of the debts owed by all of the creditors to both particular parties, that might very well have an impact on the equity that both may have in the home. That's why, looking at her judgment, she kept it separate and decided the two questions separately. She's saying, look, if I take into account all of the debts that both parties owe and make allowance for that here, would that be fair to Mr. Kanhai? Would that be fair to Mrs. Kanhai? But that's how she put it. And can I, just to complete that,
I mean, we've got paragraph 29 too,
Yes.
haven't we? Mr. Bahari Lal, we've got the second sentence. The unenviable coincidence that oversaw this court presiding over the summonses for sale nonetheless places no burden on me to incorporate those liabilities as part of the matrimonial distribution.
yes.
If the husband's interest had been charged, how could she take the husband's interest as not being charged?
Sorry, I may be...
It was a poor question. If the husband's interest in the home had been charged as a result of the registration
Yes.
of your judgment against him previously, how could the judge ignore that in considering the ownership of the home?
No, we are not saying that she did ignore that. She certainly treated them as separate, but what she's seeking to explain, as I understand her judgment, is that she's not going to incorporate that in a way that would prejudice either party's equity in the property, which is why she... whether she was right to do it is a separate matter.
You understand that point at the moment? I don't.
No. Well, I shall try and do better in addressing it, my lord. But
What she might have been saying, because we get it again at 39,
yes,
is I'm not going to order the payment out of this money to the creditors as part of the ancillary relief
Yes.
proceedings, because when you look at the authorities to which she's referred, there's a slight flavour of that.
yes,
But that's not the same as entitling her not to take into account the existence of the liability.
no, but I mean, when you actually look at the way in which she worded the judgment, milady, she does appear to have taken on board that there are these other proceedings in which orders for sale have been made.
She certainly does. By the time you get to paragraph 49, yes. She's saying there are the debts for which I've said both parties are responsible. Arrangements will have to be made independently of this judgment for those debts to
Yes.
be paid. And with the auction less than 2 weeks away, actions needed quickly is really what she's saying, isn't
Yes.
it?
And just dealing with that, milady, again, it repeats the very substantial sum of money that she says both parties were responsible for, not just Mr. Kanhai, which gives some indication whether she was right or wrong to do it as to why she kept the two separate. She felt that to take it into account might, on one view, have prejudiced both parties' interests in the property if she were to factor in the debts, etc. And she doesn't accept, I simply mention this for completeness, the respondent's argument, which she's made in her case, that all of the debts should be transferred to Mr. Kanhai and all of the assets be transferred to her. It was something she expressly took into account in trying to come to a fair distribution of the assets.
But pursuing your point that these were two separate sets of proceedings, she appears to have worked in paragraph 49 on the basis that the orders she's made in relation to sale are continuing.
Yes.
Not interfering with it,
No.
because it's going to happen in less than 2 weeks, so
Yes.
you'll need to take action quickly.
Absolutely. And we say that that was a direct reference, although it may be unwise for a High Court judge to say it in a judgment. But the way in which you read the judgment, particularly paragraph 49, appears to be highlighting to the reader, in particular Mrs. Kanhai, if you wish to challenge the orders for sale, then you must act independently of this decision, these proceedings, to do it.
Well, I think what she's saying is you have to pay the debts.
Well, if
rather
they're
than
going
talking
to...
about court proceedings.
Quite, but without it being expressly said, both the argument I've made about the procedure available and secondly this particular paragraph should have highlighted to the reader, highlighted to the respondent, if you wish to challenge these orders for sale, if you can't pay the debt, if you don't wish to pay the debt, then the proper course of action would be to challenge the orders for sale. And We say that any practitioner reading this judgment would have been quite concerned. Look, your remedy here is to make the orders for sale, is to challenge the orders for sale.
Suppose, this is a point on the interrelationship between the two sets of proceedings.
Yes.
Suppose your appeal succeeds and you're therefore entitled to an order for sale and half the proceeds, and suppose at the same time as we give our judgment, the Court of Appeal in Trinidad and Tobago gives judgment allowing the wife's appeal and saying she has an 80% interest in the house as a result of their property adjustment order. What's the position then?
Well, there would still be, from our point of view, sufficient equity in the husband's share to meet a substantial part of the monies owed. But the way in which the directions were framed rather suggests, and when you look at the procedure, that any monies that come out of the auction don't immediately go to the creditor. There is a procedure that you could build into the order.
So
But
you-
either,
Sorry.
I'm so sorry, my lord, I interrupted you.
Sorry, you do finish, then I'll put my...
Either way, when one looks at the amount of debt that is attributed to both the respondent and Mr. Kanhai, it seems inevitable, we say, that this property will have to be sold, even if she were to acquire 80% of the interest, or even a substantial part more than that, which would be, we say, unusual. On the information we have, she too is owing debts, which the judge did not want to factor into when she made the decision in relation to the matrimonial home in these proceedings.
So do I understand your position to be this, that if your order for sale goes ahead, the percentage of the proceeds which you can take will be affected and possibly reduced by the Court of Appeal's decision in the matrimonial?
Potentially, if the Court of Appeal were to change or reverse the judge in any particular way, because at the moment it's
50%.
50%. But if the Court of Appeal were to make an order that varied that, it can have an impact
But
on
how
the
could
amount
that affect,
available for the creditors.
how could that affect a registered judgment and therefore charge of a
Well,
prior chargee?
the-
Unless the order was simply rewriting history in the sense of saying it had
Well,
always been only
forgive me,
20%.
I thought I was answering if the board accepted that you could vary the interest. One of our arguments that we make in this appeal is that you cannot vary the interest after registration because the statute says it locks as at the date of the registration of the judgment. We don't accept, and as we've not accepted in our case, that the matrimonial proceedings can affect it at this stage. We don't rely on the judgment of Ram Kerry Singh for the purposes of saying, well, she's ordered 50%. What we say is that from the moment the judgment was registered, unless the board says it can be affected, which is one of the questions we raise, we say that the statute is clear. The Remedies of Creditors Act in various sections, which we've set out in our case, I'm not going to take the board to it unless it would be helpful, specifically uses the words, the beneficial interest as at the date of registration.
Sorry, then there was a misunderstanding.
Sorry.
My question to you was on the premise that you win the appeal.
Yes.
Suppose you win the appeal, you have an order for sale, and you say that entitles you, subject to calculating how much interest and so on there is, to up to 1/2 of the proceeds, but the Court of Appeal in Trinidad and Tobago says that the wife's interest should be adjusted to 80%. What is the position there?
Well,
How do the two proceedings interrelate?
Well, this is the difficulty that arises with not appealing the orders for sale. This is why we've come to the board. Because on the one hand, we have valid orders for sale for half of the equity in the property. It stands unchallenged under the Remedies of Creditors Act, and yet they're not able to secure that.
Well, Mr. Behenala, I don't think you've answered Sir Rupert's question. Surely, one of the problems about this case is that people haven't yet realized that a court can say two different things. Let's take Sir Rupert's 80% for the wife, which may be very ambitious for all I know. A court could say, the wife, it was in joint names legally, but the wife has always owned 80%. Or it could say, the wife has owned and today owns 50%, but we will adjust under the Married Women's Property Act, Married Women's Proceedings and Property Act, to 80%. In other words, that was the position, but we are changing it. Now, the first possibility, which I don't think is a real possibility on the facts of this case, subject to what Mrs. Seaborn-Sweet is going to say, the first possibility of the court saying, she's always owned 80%. Now, that would be very prejudicial to your clients. But I think you would say, if the court says she owns 50%, but we are going to adjust it because of the divorce to 80%, I think you're going to say that that couldn't prejudice you because of the charge that you've got on registration of your judgment. Is that roughly how you would put it?
It is, but my Lord Wilson puts it better than I. But that is the argument we've made in our case for the appellant, that it cannot affect the creditor's position because of the date of registration of the judgment. And that unless the board is going to say that the Matrimonial Proceedings Act proceedings can adjust the date, the beneficial interest as at the date of registration of the judgment, if the board were to say that, then we come into what I thought my Lord Sir Rupert was asking me, then that could have an impact. But we say it can't have an impact because as at the date the registration is made, it locks on the interest existing as at that time. And if there were any adjustment to be made by the family court should take that into account, that order is an order that will have to be fulfilled.
Now, in England and Wales, the first disposal, namely, she has always owned 80%, would be a disposal that would be cast under Section 17 of the Married Women's Property Act 1882. Correct me if I'm wrong, but I think that the analogous act in Trinidad and Tobago would be the Married Persons Act. Is that right? And have you got a copy of it?
We don't have a copy of it, my Lord.
Is there something called the Married Persons Act?
Your Lordship asked me the question. I'll have to check it, and I don't...
I mean, my judicial assistant,
Yes.
because I felt I didn't have enough of the Matrimonial Proceedings and Property Act.
I think we're being...
I'll come to you in just a moment. Thank you. Thank you for waving your arm. I will come to you in just a moment. My judicial assistant has given me more sections of the Matrimonial Proceedings and Property Act that the parties gave us. And in Section 60 of the Act, it says, nothing in this part, which is to do with proceedings about occupation of the home, shall affect the powers of the court under Section 12 of the Married Persons Act. And that led me to wonder whether the analogue to the English and Welsh Section 17 was Section 12 of the Married Persons Act. But I may be wrong about that. And before you answer,
Yes.
I want to go, please, to Mrs. Seaborn-Sweet, who was raising her arm a few seconds ago. Mrs. Seaborn-Sweet.
My Lord Wilson, I was just raising my hand to agree with your Lordship that indeed Trinidad and Tobago does have a Married Persons Act, which replicates the provisions of the Married Women's Property Ordinance, which has been repeated and replaced by the Married Persons Act. That was all I wished to say, my Lord.
Thank you very much indeed. Mrs. Seaborn-Sweet is saying that my instinct was, for once, correct, Mr. Baharila.
I'm sure many more times than once, my Lord, and I now have it in front of me. I think the...
What's it say?
Subject to this section, in any question between husband and wife as to the title or possession of property, either party may apply by summons to a judge, and the judge may make such order with respect to the property in dispute as he thinks fit, or may direct the application to stand over from time to time, and any inquiry touching the matters in question to be made in such manner as he thinks fit. With the avoidance of doubt, it is hereby declared that any power conferred by subsection 1 to make orders with respect to property includes power to order a sale of the property. Subsection 3, any right of a party to a marriage under subsection 1 to apply to the judge to apply to a judge includes the right to make an application. I don't know whether your lordship wants me to
I
go
don't
on.
think we need any more.
Can you just give me the section number?
It's section 12. Question, the margin note as a short reference, questions between husband and wife as to property may be decided in a summary way.
So that would be the vehicle on the islands for a declaration that, hypothetically, the wife here has always owned 80%. Now, there's been no claim under Section 12, and there's been, Mrs. Sieber and Sweet, in due course will correct me if I'm wrong, there's been no suggestion in any of the material put forward by the wife that she has always owned more than 50%. It's all been done under property adjustment. Is that right?
That is correct. We have always understood, from what we've been told, the application is pursuant to Section 26. And forgive me, I did not have this case, the statute at my fingertips, but only because, and it may be my fault, and I'm sure it is, that none of this has featured in any proceedings so far as a power that the court was considering they were acting under. And so that is why we've confined the appeal primarily to the Remedies of Creditors Act and the Matrimonial and Property Proceedings Act.
So is the answer to my question that if the Court of Appeal gives a judgment adjusting the wife's interest to 80%, that judgment will be of no practical effect whatsoever?
We say that it would be of no practical effect, but my Lord, my answer is in this way. Bearing in mind that the High Court judge and the Court of Appeal would be aware of the orders for sale that were made under the Remedies of Creditors Act, surely the consideration as to what orders they would make in the family proceedings must include the obligations to pay under the orders for sale. That it would be taken into account, if you like, the other way, not the family proceedings overriding the creditor's judgment, but rather the family court taking into account that there is this judgment that would have to be paid from 50% of the equity in any orders or final orders they may make.
But the creditor must still be protected if the court does not know. This is really a question of priorities, not about procedural steps of whether somebody appealed or didn't appeal.
But to answer my Lady Arden's question observation, this is one of the things that is difficult about the Remedies of Creditors Act. It is supposed to give priority and lock as at the time of registration of the judgment. And this is what all of the provisions, sections 5 to 8, say. That as soon as you can't just get a judgment, and that will give you priority. You must register it, but once you have, it's as if the person concerned charged the property with his own hand, to borrow a phrase from the legislation. And because the certificate of title at that time had them as joint tenants, and that is specifically dealt with in the Act, the family court coming much, much later to consider the question of the matrimonial property, surely it must be the court to consider that this is a debt that must be paid, which is locked onto 50% of the equity of the property. Because that was the position at the time of registration. That was Mr. Kanhai's beneficial interest.
To be pedantic,
yes,
it wouldn't necessarily follow from joint names that the beneficial interests were equally shared. But putting that pedantry on one side,
in fact,
it has never been
suggested
otherwise.
Yes, but on the face of it, there's nothing to suggest on what we have seen, on what the creditors were provided with, that the equitable split disclosed by the certificate of title was challenged. We've made this point in the case for the appellant, but there's nothing in the record that indicated at any time that what the respondent was seeking to do was to extinguish the entirety of Mr. Kanhai's beneficial interest. And I raise that, my lord, because in the issue that is being presented to the board by the respondent, she relies heavily on subparagraph D, the extinguishing of the interest of the husband. Well, we say that, one, that is unlikely in light of the judgment of Ram Keri Singh, but in any event cannot affect the proceedings that have already come to an end, in effect, with the orders for sale. And this is why, unusual though it may be, different judges make different orders. The same judge made the orders for sale. And if the respondent wished to challenge that, there was a way to do it, and this wasn't it.
But here,
Sorry.
the creditor's interest is registered under
Yes.
the ROCA, and then, as I understand it, does it go onto a property register as well?
Yes, once it's registered, because it's a centralised register with the Registrar General, it locks onto, for example, the Registry for Registered Land. This came up in another case, but the Real Property Act, which we've mentioned in the case, this is registered land, and so the registry is the same. And Lord
Yes.
Hoffman touches on this, the centralisation of registration in Trinidad, which makes it much easier.
So anybody dealing with the property, if you take a purchaser who comes along, for instance, would know that the creditor had an interest
Yes.
over the 50%.
Would get the registration of the appellants in this case.
So
Sorry, I'm so sorry.
I was going to say, would there be any argument that the only way to obtain priority, therefore, is by a prior registered interest on the property register?
Yes, that, in fact, I haven't taken the board to the cases yet, but I will do. But essentially, depending on how you are registered, the order of the various creditors who are registered, you have priority in that order in the normal way. The only question that may arise is any issue about re-registration, which may not affect, if you haven't re-registered, any subsequent creditor may gain priority over you. But other than that, those who are already on the register go in a certain order.
So subject to re-registration
Yes,
at the end of 3 years,
yes.
the creditor in our case would have priority over anyone else.
Yes.
So it's a question of priorities according to land law.
Well, I wouldn't have phrased it in that way, but certainly this concerns land, and so in this context, yes. But under the Remedies of Creditors Act, they are seeking an order for sale. It's not chattel. So I think the short answer to my lady's question is yes.
Mr. Baharal,
in this case, sorry.
You were minded, I think, to answer Sir Rupert's question, or would the family judges a property transfer order or a property adjustment order by the family to be ineffective once there had been a judgment and a registration of the judgment giving the creditor a charge? Is the position this in Trinidad and Tobago, that the effect of the registration of your client's judgment gives rise to the same position as if the husband had at that date charged his interest in the property to the creditors? So what he has left, because it might be charged to secure quite a small sum of money, is an equity of redemption, which might itself be a valuable piece of property which could be dealt with in the family proceedings. In other words, he wouldn't have a 50% beneficial interest in the property, he would have an equity of redemption in a beneficial half share of the property because he charged that half share, or he was treated as having charged that half share by the registration of the judgment.
Well, the way in which the Remedies of Creditors Act has been phrased, my lord, is that it goes beyond merely a matter of charge. We would say you have priority. You've got priority under the Act.
I thought that's what it said.
Well, it may be helpful if I just...
Surely Lord Briggs is making a valid point, Mr. Baharilal. In the family jurisdiction, the court has to work out what the assets are.
Yes.
Here's a husband with a half interest. Oh dear, it's charged. It may be charged for a sum less than the value of the interest. Then there's an equity of redemption. That is owned by him beneficially. And that is an asset that we must take into account. So I'd expected your answer to my lord to be, yes, I entirely agree.
I may have misunderstood the question, and it may be I do agree. However, what I wanted to draw the board's attention to is to the sections.
I'm looking at Section 5.
Section 5.
442.
At 442. And this section only deals with the actual judgment that operates as a charge on all of the lands. But then if you go to...
But don't we need to look carefully at this section before we jump on to what the effect of registration is?
Yes.
The judgment itself, as I understand it, operates as a charge.
Yes.
All relevant lands or interests, because it says for any estate or interest whatsoever when possession, reversion, remainder or expectancy over or over which that person shall at the time of entering up the judgment or at any time afterwards have any disposing power which he might exercise for his own benefit. Now, all that lengthy language would mean that it operated there and then as a charge on his beneficial interest in the property.
And that I agree with.
And then when it's registered, it gains priority.
Yes.
But however that may be, once you get to the family property adjustment jurisdiction, it bites on what he's got left, surely, which, if he's charged it, is an equity of redemption.
Well, the short answer, now that I think I've followed my Lord's question, is yes.
Okay.
But
You'll forgive me, but I'm struggling to catch back up, as it were, with a property system which I think doesn't have our 1925 property legislation. I just want to make sure how it all works in proprietary terms.
Yes.
Mr. Baharilal, as a result of our questions, partly, and in particular, I suppose, as a result of mine, for which I apologise,
no, not
you only have 13 minutes left.
Yes. Can I deal, please, swiftly if I can, with the authorities bundle? And I think the board has the point, unless there's any particular issue you would wish me to address, that we say that jurisdictionally it simply couldn't have been done in this way. But can I now take you to the authorities that operate under the Remedies of Creditors Act? We've cited a number of cases, and can I take you first, please, to page 582, which is the case of Walker and Lundborg. And it's really page 595 of that case, decision of Lord Walker. Paragraph 77. And this was the question of delay. Forgive me, my lord, page 595. This was the question of delay, which we say was not properly dealt with by the respondent when she applied for the stay. We say that if there was an urgency, it was on the 17th of March 2015, and that is when she ought to have made her application, both the appeal and the stay. She didn't. And insofar as the Court of Appeal considered this application for a stay and rejected the appellant's application to set it aside, they did not consider, nor did they ask, why was it that the respondent took the better part of 8 months to lodge the application and didn't assess the answers that may have come. Now, we see in the respondent's case that she says, well, that's because there was a stay. Well, we've illustrated there was no stay of the March 2015 order, and we also illustrate that if there's a sense of urgency in relation to the orders for sale, where the appellants complied with the directions, and that is significant, they complied with the directions made under the orders for sale, and the auction was fixed. They couldn't have got that far unless they had, at their own expense. The Court of Appeal should have asked, and did not ask, well, why did it take you this long? And we rely on paragraph 77, that in effect, the grant of a stay is discretionary, and if it's discretionary, the Court of Appeal needed to ask, you're asking for an extraordinary exercise of discretion in a case where orders for sale have been made, which have not been stayed by the judge. Have you acted promptly? And have you explained, if you haven't, why you have not acted promptly? And we say, my lords, that there was no answer to that, nor is there an answer now. My lord, we've also relied on the cases of In Re Citra, and if I could take the board to page 554. and because of shortness of time, if the board will forgive me, I'll give you the reference, but perhaps take you to the head note. If you can look at page 554, and it's the fourth line of the head note. No distinction was to be made between a case where a property was being enjoyed as the matrimonial home and one where it had ceased to be so used, that where a spouse having a beneficial interest in such property had become bankrupt, the interests of the creditors would usually prevail over the interests of the other spouse, and sale of the property ordered within a short period. That only in exceptional circumstances, the operative word, more than the ordinary consequences of debt and improvidence, could the interests of the other spouse prevail so as to enable an order for sale to be postponed for a substantial period. And that accordingly, since the circumstances of wives and their children, albeit distressing, were not exceptional, the order sought by the trustee should be made. Now, in this particular case, my lord, we rely on that as support for the proposition that here, in this case, where the judgment was entered in 2012 and registered in 2013, and the order for sale made due to a long delay in 2015, that this is not a case where the Court of Appeal ought to have granted a stay of the orders for sale. And that's notwithstanding any argument in relation to whether they were right to do it in these proceedings.
We haven't got time to do it now, and you haven't got time to show us. But when we look at in re citro for ourselves,
Yes.
we'll have to see whether they were talking about secured debts,
Yes.
or, as I rather think, unsecured.
Unsecured debts.
Well, there we are.
But here, we say that we have a secured
Quite.
debt. And again, so that the board has it, it's page 568, B to D.
Very well.
Lloyds Bank and Burn, page 575, again, take you to the head note. This is dealing with section 30 of the English legislation, was entitled to apply under the section for the sale of the property. The application was made in relation to property acquired jointly as a matrimonial home, and a spouse having a beneficial interest had become bankrupt under debts which could not be paid without realization of that interest. The broad effect of the authorities was that of the voice of the creditor would prevail over that of the other spouse, save in exceptional circumstances. In the present case, where the bank as the person interested was a charge and not a trustee in bankruptcy, the same principles applied. And this is the important part. The purpose of section 30 was to enable the court as a matter of discretion to say that this was a discretionary order that was made, which was not impeachable, to do what was equitable and fair and just. All the circumstances must be weighed, and the court must consider whose voice must in equity prevail. And so in answering one of my Lord Wilson's question as to the balance between family proceedings and the debt proceedings, you take it into account, but what weight you attach to it is a separate matter and a matter for the judge. And here, on the facts, the Court of Appeal of England did not consider that, did not have any doubt that the voice of the bank, where you had an ever-mounting debt that couldn't be satisfied without the sale, was exceptional, and they hold that it was not exceptional. And just so that the board is aware, because the interest rate in this case was 12% at the time, it's 12% that is running, as with the debt, which was originally approximately £50,000, but with the assistance of Miss Sutcliffe and Miss Hitchins this morning, seems to be getting closer now to 100 because of the interest. And so this is why
It's closer to what, 100,000
£1,000.
pounds, not dollars?
No, because I'm giving the equivalent, my lord, in pounds. It would have been approximately £50,000 as at the date of judgment. And we've set that out in the early part of our case.
What is it in Trinidad and Tobago dollars?
It would be
330 something.
it would be approximately, if it's £100,000, just under $1 million TT dollars, potentially, because of the length of time. I can give you, my Lord, an exact figure a little later, or an exact approximate figure. The reliance on both of these authorities, my Lord, is really to show that it's not exceptional, and that this case was not exceptional to justify a stay. Can I also take the board now to page 597? And it's next page, Agricultural Development Bank, page 598, the first two paragraphs. And it's paragraph 1, really. Once a judgment has been received, it is left to the judgment creditor to choose the most effective means of securing the fruits of his judgment. No hierarchy among the available methods. The choice of mechanism of enforcement is not an issue for the court, whose role it is to ensure that whatever method is used, it falls within the purview of the law.
Well, that's all pretty obvious
Yes.
stuff, isn't it?
Yep.
Yes, what else? Bearing in mind the time.
Yes. Can I take the board, please, to the decisions of the board, which has considered this, which may be of more relevance. First case is Passard versus Royal Bank of Trinidad and Tobago, page 673. And it's paragraph 22. And it's really underscoring this point that my Lord Briggs, I believe, was exploring with me. What do you have as at the date of the order? And the board in that case, talking about the Remedies of Creditors Act, authorises the court to order the sale of the execution debtor's beneficial interest only, and was properly limited to Mr. Budram's beneficial interest in the property. The order was therefore intrinsically valid but had no content, for as at the date of the order, Mr. Budram no longer had any beneficial interest in the property. And so that really deals with this point that the Remedies of Creditors Act, we say, locks as at the date of registration of the judgment and cannot be subsequently altered. Can I now take you, please, to the Trinidad Home Developers case and invite you to look at, please, page 682. And it's middle of paragraph 24. Part 2 of Rocker, on the other hand, includes a detailed code of execution. A judgment creditor can proceed to execution in two ways, underscoring the point that the proper course here was to seek remedies under the Act, and the bottom line, alternatively, under Section 37, a judgment creditor whose judgment has been registered may proceed directly to execution against the debtor's land by filing an affidavit given particulars of land to which the debtor is beneficially entitled. And then finally on this case, page 686, paragraph 39, which we have relied on in our notice of appeal, to say that the entry and registration of the judgment not only creates security of the land but also counts as part of the process of execution. Well, we say, my Lord, that if that is right, then it cannot mean that the matrimonial proceedings can alter it subsequently. That's the short point in relation to that. My Lord, the last case...
Well, you see the time?
May I give the reference, and I'll sit
Give
down.
us the reference.
It's page 706, middle of the page.
Yes.
In summary, don't read it out. And then page 711, paragraph 74, which the board may wish to turn up, which deals with section 54, which is the section under the Remedies of Creditors Act, under which the court can consider whether to stay an order for sale.
So, Mr. Baharilal, is that about
I'm
it?
sorry if I've gone over my time. I
Don't
haven't
worry.
actually intended to, And with some of the questions that I may not have answered fully, I'm going to give them some more thought now, and I'll try and do better when I reply, if I may.
Well, a reply is a reply, strictly speaking, but let's continue.
Well, if I can assist the board further,
Thank you.
put it that way. Can I
Miss
assist the board?
Sutcliffe, this is a courtesy inquiry only, because the time for the appellant submissions is up. But out of courtesy, I must ask you, do you follow? Thank you. Right, now, Mrs. Sieber and Sweet.
My lord, I will get right to the heart of the issues that have been being raised by my friend, and that is to
Mrs.
say
Sieber and Sweet, we're already having difficulty hearing you. Now, what can you do? Have you got an engineer with you?
Yes, I do.
Have you got an engineer with you?
I can perhaps ask my technician to take me off the large screen and bring the computer much closer to me. Because we're looking at you on a very large screen, but in fact there is a computer which is with a smaller screen. If we brought that forward, you might be able to hear me better.
Yes, please.
Would you bear with me, my lords, while we attempt that?
Do you think we ought to retire for a moment and ask Ghazi to try to help her to speak more loudly?
Well, she thinks there's a computer she can bring forward, which is the thing that's got the microphone in it that she's...
Can you bring your computer forward? Is that going to help?
This is what I was proposing to do, my lords and my ladies.
Yeah, absolutely.
What?
So,
Yes. Mrs. Sieber and Sweet, we've got a wonderful engineer here, and we're going to retire for 2 or 3 minutes, and he's going, if you'll accept this, to talk to you about what you can do to enable us to hear. Is that acceptable to you?
certainly, my lords.
Thank you. Mrs. Sieber and Sweet, we are told that there will be no particular problem now about hearing you, and I'm so happy to hear that news.
So am I, my Lord Wilson.
Good.
You invite me to commence, I take it?
Sorry?
Shall I go ahead? Shall I proceed?
Go ahead, please.
Yes. I will straight away get into the nub of the issues that have been being raised by my friend, and that is to say, what was the nature of the order of the Court of Appeal referring the summonses for sale to the family court judge. And I would direct, my lord, my ladies, to page 129 of the record, which contains that.
Hold on, please. 129. Yes, we've got it.
Yes, and my lords will see that at the operative part of the order, at where it starts, it is ordered. What is ordered is as follows. It is ordered that the appeal is allowed. The order of the judge dismissing the application dated the 7th of February 2013, the summons for sale, is set aside and is reinstated and remitted for hearing for the High Court. and to be heard together with the ancillary relief proceedings before the respondent and Glenda Kanhai, now pending before the family court. So that therefore was the order that was given to Madam Justice Ram Kerry Singh, that she was to hear the summons for sale together with, it's an order that is made under the consolidation power or the consolidation type power of the court, which is that you can either specifically consolidate or you can order that matters be heard together. So the specific order that was made here is that the matters be heard together. And in my submission, I am afraid that Madam Justice Ram Kerry Singh erred in that she did not hear the summons for sale together with the application for ancillary relief, but rather plucked it out and dealt with it prior to her coming to her judgment and her reasoning on the ancillary relief application. And so in that way, my submission is that she fell into error in not complying with the direction she received from the Court of Appeal that she should deal with the summons for sale at the same time as dealing with the application for ancillary relief. If we look at her order for sale, and this, I would ask the court to look at the order for sale made on the 17th of March, 2015, which is to be found at
Next page,
just
is
bear
it?
with me, my lord.
Next page, 130.
130, thank you. The order, I am addressing the question of whether the order for sale was in fact stayed in its specific terms. Now, what was said at clause 4 of the order for sale on page 131 of the record is that notice of the sale shall be advertised in a daily newspaper in general circulation in Trinidad and Tobago twice per week for 4 consecutive weeks. Such notice to be settled by the registrar and shall not be published before the 5th of June 2015. Now that operated in effect as a stay in the sense that the rules provide that the sale being advertised on the 5th of June, the sale could not possibly have taken place before the expiration of 4 weeks, so that the sale would then not have been able to go through until somewhere after the 4th of July 2015. And so this is the sense in which, albeit that Mrs. Perryman-Pollard said before the Court of Appeal that there appeared to be some sort of concession that this order did not in itself contain a stay. The effect of it was that the order for sale was not to take place until sometime distant from the order, the making of the order itself. Now, what the effect of her having made this order and having stayed and having postponed, as it were, the actual sale engendered in the mind of certainly the wife. And in my submission, it was a reasonable view that when she came to give her reasoned decision on the ancillary relief application, she would revisit the question of the summons for sale. So that it was very much the understanding, the reasonable understanding of the wife and the wife's attorneys that the judge, having made her summons for sale in this way, and then proceeding at a later date to give her reasons on her ancillary relief award, that we very much expected, and in my submission, a reasonable person would have expected that she would have revisited the issue of the stay.
We understand that, but Mr. Baharilal would say How could you have expected it to be revisited in the matrimonial proceedings if the companies weren't parties to them?
Well, our understanding that both sets of proceedings were being dealt with together. Both sets of proceedings were being dealt with together, and all parties had an opportunity to be heard and to make their representations, so that there would, in our mind, not have been any question of any difficulty of revisiting the summons for sale at the order for sale at the time of coming to a judgment.
Yes?
Now, when and what we see is that the learned trial judge, if we look at her judgment itself, which is contained at page her order, her judgment, which begins at page 346 of the record, you will see that straight away in delivering her reasons, the difficulty that had been engendered by the trial judge having, as it were, preempted her own self by making the order for sale at that early stage, becomes manifested immediately as you begin to read the judgment. Now, it was not that the Court of Appeal directed her to order a sale. The Court of Appeal directed her to consider the question of whether an order for sale should be made. And in looking at her reasoning as to when she made the order for sale, it appears that the only consideration she had in mind was the commercial right of the Dutch companies to recover their judgment. When she then came to her reasoning and in her judgment, for example, at paragraph 4, this is what she said. 2 of the summonses for sale were initially dismissed by my brother Sipasad, but reinstated by the Court of Appeal and remitted to me for disposition. At least 3 other of the parties' creditors, taking the cue from the first 2, filed summonses for sale before me. Predictably, the judgment creditors' attorneys were anxious to secure their clients' judgments and sought orders for sale on the 17th of March 2015. And what the learned trial judge says is, I felt constrained to make the orders, given the substantive matrimonial applications ought to have been disposed of long before, that they had not been interrupted, and had they not been interrupted by many intervening applications. She makes no comment on which of the parties was the cause of that lengthy process, or indeed of the fact that she did herself have conduct of the trial of the matter. But the point is that in saying that she felt constrained to make the orders for sale at a time prior to considering her ancillary relief award, seemed to be out of step with what she was directed to do by the Court of Appeal in dealing with both of the matters together. So that when she comes on to paragraph 6 of her judgment, she says, it has always been the wife's position that the husband should bear the full liability of any judgment which should be reflected in any orders the court intends to make. But I have deliberately treated the 2 sets of proceedings separately, and in the application under consideration, I have confined the division of the assets as between the parties only, and then goes on to say that she outlines her reasons below. Now, contrary to other assertions and dicta of the learned trial judge, she attempts to keep the question of debt of the parties away from her adjudication, which is in fact contrary to the factors that are set out in the Matrimonial Proceedings and Property Act, Section 27, which requires the learned trial judge to consider the means of the party, both assets and liabilities. So in our submission, she fell into error by attempting to divorce her mind from the debts of the parties. And of course, it has been always the position of the wife that she, having been excluded from the business since 2009, well below the party separation in 2011, and they having operated prior on a cash basis without having to have recourse to borrowing, that these debts would not be for her account. So that her submission in the trial and on appeal is that the debts should be declared not to be for her account, that all of the debt should be for her husband's account. And indeed, the relief that she is seeking in her notice of appeal is that the entirety of the interest in the matrimonial home be transferred to her. So that the learned trial judge goes on at paragraph 31, to be found on page 360, to say as follows at paragraph 31.
31.
But perhaps before we go to, forgive me if I were to ask you to go back to paragraph 29.
29,
What is said
yes.
about is that what the learned trial judge says is, I want to stress that no attempt will be made in these proceedings to order payments out to the judgment creditors. The unenviable coincidence that oversaw this court presiding over the summons for sale nonetheless places no burden on me to incorporate those liabilities as part of the matrimonial distribution. The judicial split between the matrimonial and civil proceedings are not helped by the fact that the order for sale preceded this judgment. But I felt that, and so on. So what I'm saying, my lords, is that it was wrong for her to have considered that it was not appropriate for her to take questions of debt of both parties into account in making her award.
Well, Mrs. Sieber and Sweet.
Yes.
Your Matrimonial Proceedings and Property Act looks as if it was to some extent modelled on the one that we had in England and Wales in 1970. Now it's been replaced by a 1973 Act.
In 1970,
Lady Black and I both served in the English and Welsh Family Division. So we do understand the points that you're making about her separation. And no doubt those were points that you made very actively before the Court of Appeal.
Certainly.
And we await their judgment. But surely the basic point that you have to address to us is how, if there's a judgment against the husband which is registered and attracts the automatic charge on his interest in the home, how the judge was able and how you would be able in argument to say that that charge can be ignored and that the wife should have some interest in it, whether of the sort chosen by the judge or a larger interest, without recognizing that his interest was charged. That, to my mind, is the basic point that we want your help on.
Very well. What we are asking the Privy Council, your committee, my lords, to do is to set aside that order for sale that was made, that premature order for sale that was made in the civil proceedings by the Dutch companies. What we are asking you as the Privy Council is to set aside that order on the basis that that order was made in error and was made prematurely.
But you haven't appealed it to your local appeal court.
Well, those submissions in arguing the appeal before the Court of Appeal, we certainly vociferously argued that the learned trial judge was wrong and premature in making that order for sale.
Yes.
So that we feel that the Privy Council has the jurisdiction to make pronouncements and indeed overturn, because this is in fact the proceeding which is before the Privy Council. And if it is that my friend stands by his submission that the summons for sale was made in the civil proceeding, I beg your pardon, the order for sale was made in the civil proceedings, we certainly believe that, my lords, my ladies, you have the power to set aside that order for sale as having been a premature exercise of a discretion that had been remitted to her for consideration rather than for a, as it were, summary decision, that it having been remitted to her, it seems as if she felt obliged to make the order for sale at the earliest opportunity, when in point of fact, to me certainly, to us certainly, it appeared clear that what she was being directed to do was to consider the question of the sale of the matrimonial home at the same time as she was considering her award on ancillary relief.
Can I just ask you something, please? What you're appealing to the board is an order of the 19th of September 2016. That isn't an order for sale. It isn't the Court of Appeal dealing with the order for sale by the trial judge. That is an order about a stay. It's not your appeal, it's the other side's appeal.
Yes, it's the other side's appeal.
You haven't cross-appealed in any way in relation to the order for sale. And yet you say that there's jurisdiction in this court to set that order aside. Is that,
yes,
have I got your argument correctly?
Well, that is my argument, and I feel convicted that the Privy Council does have that power. Certainly, the Privy Council has the power to pronounce on the correctness or otherwise of that decision. At its lowest, the Privy Council can pronounce on the correctness of that decision and on the prematurity of that decision, having regard to what was clearly intended by the Court of Appeal in remitting it back to Madam Ramkari Singh. And what I do agree that what the board, the committee has before it is an appeal of a decision of a single court of the Court of Appeal in the divorce proceedings, staying the sale of the property, so that what there is an order of the Court of Appeal confirmed by the full court, staying the sale of the matrimonial home. The question as to the validity of that order and as to it having been made in the matrimonial proceedings as opposed to the civil proceedings is a difficult question and a ticklish question. However, it certainly would put any prospective purchaser of the property in a bind were they to be faced with an order of a superior court of Trinidad and Tobago attaching to the matrimonial home, and in respect of which the order for sale, according to the arguments of my friend, can only attach to 1/2 of the, let us say, the equity in the property, because on the face of the certificate of title, the parties are joint tenants. So that there is a very practical difficulty with respect to the, as it were, orders that are now attaching to the property. And this is why I say that I do appreciate that we do have two separate proceedings here, but there is no sense in which the civil party, the appellant in this matter, did not have notice of the applications, were not given. Indeed, they have. They have come to the court and they engaged in a substantive appeal before the Court of Appeal, seeking to set aside the order of the single judge, where this was not the burden of their argument. The burden of their argument was not that these were separate proceedings, that sort of, may I say, fairly technical point, but rather that the registration took effect at the time when the judgment, the fetter on the title took effect at the time of registration. That was the point that was so vociferously argued before the Court of Appeal. And it is the refusal of the Court of Appeal to accede to and accept those arguments that has caused my friend now to be, has caused it to be in the Privy Council. So it does present a challenge. It does present a difficulty, but in my submission, it is a technical difficulty. And I dare say that if it is that the merits of the case suggest a somewhat different outcome, that we can find a way to deal with it.
Sir Rupert wants to ask you a question, please.
There has been another hearing in the Court of Appeal where I expect you represented the wife, a recent hearing.
Yes.
What were you asking the Court of Appeal in the summer of this year to do about the house?
I was asking the Court of Appeal to declare that in the award, the house in its entirety would go to the wife, and that the business, indeed the house and the other item of real estate involved, would go in its entirety to the wife, and that the business would go to the husband. And this was in the context of findings of the learned trial judge, that the business was lucrative, the business was ongoing, the business was prosperous, but it was clear from the matrix of facts before the learned trial judge that it would be extremely difficult to quantify or to value that business. Indeed, in the trial, the husband brought an accountant to give evidence on his behalf, who openly admitted that this was a business that kept no accounts, kept no records. So this is the context in which we said it was an erroneous exercise of the learned trial judge's Ram Carey Singh's discretion to order that that business be valued and that the wife get 1/2 of that business, because this was her order. Her order was the wife should have 1/2 of the matrimonial home and 1/2 of the business, and that the wife and the husband should cooperate in valuing the business, and that the husband should pay the wife a lump sum representing her 1/2 of the business. But that was manifestly unworkable, having regard to the conduct and behavior of the husband, as had been pronounced by the learned trial judge herself. And if my lords, if I could direct my lords to the notice of appeal, which is to be found on page 375 of the record, my lords will see that what was being said at the top of page 375 was as follows. The above award, which was to award 1/2 of the business to the wife and 1/2 of the property to the wife in circumstances where the business had to be valued in cooperation. So what's said here is the above award is wholly erroneous in light of the following findings of fact. And the findings of fact that we highlighted were that the respondent was not a witness to the truth in his allegation that he had transferred the business to his brothers, that he had made deliberate attempts to mask the true earnings of the business, that there were inconsistencies in his evidence as to the disposition of some £80,000, which was on hand at the commencement of the matter, that the respondent refused to disclose the true nature of his finances, and so on. So that the burden of our appeal was that, having regard to the findings against the husband of the very trial judge, to order suggesting that it was feasible for the parties thereafter to cooperate for the valuation of a business which had no accounts, and out of which she was, since 2009, was wrong. Yes, my lord.
Following on from Sir Rupert's question and your helpful answer, the supplementary question that I would put to you is, what were you contending before the Court of Appeal should happen so far as the debts to these two companies are concerned and all the other debts?
We were contending, my lord, that these debts should be attributed to the husband. That these debts, so therefore we challenged the finding of the learned trial judge that the wife was equally responsible for these debts. The learned trial judge cast aspersions on the credibility of the husband, and the wife's evidence was that during the pendency of this marriage, they operated on a cash basis. They never took credit, they never borrowed from the banks, they built the matrimonial home out of cash proceeds of their business, and that the husband was a witness of untruth in suddenly acceding to numerous civil actions brought against him, where he challenged none of them and admitted liability on all of these judgments. What we say was, we could not prove collusion on his part together with his suppliers, such as the Dutch companies. All we said was that the highest that we could put it was that the judge should find that these debts were for his account, and having regard to what was said about the prosperity of the business, those debts should have been apportioned to the husband, along with an order leaving him with the business, and then leaving the wife with the two items of real estate, one of which was the matrimonial home. So that is what we were content.
Thank you.
Before. So to continue, yes.
Lord
Yes,
Briggs wishes to ask you a question.
Certainly.
I think I understand from page 378 of the electronic bundle, which is a passage in your notice of appeal to the Court of Appeal, in the first paragraph on that page, that you were seeking tell me when you've got there, that you were seeking an order that the Court of Appeal transfer to the wife the property free from encumbrances. In other words, as I understand it, free from the Zwarte Band charge.
Yes, that is exactly what we were asking.
In other words, as I understand it, you were asking the Court of Appeal effectively to set aside the charge as part of the relief which you were seeking in the matrimonial proceedings.
In the sense that we would say that since the property was being awarded to the wife and that the business and debt was being awarded to the husband, that the property would then be free from the charge. And that is why we felt that the learned trial judge was premature in ordering the sale of the property before she had made up her mind as to what she was going to do in the award. And we felt that this could have been the only reason why the Court of Appeal remitted the summons for sale back to her, not for the making of an order for sale, but for her consideration at the same time that she was considering the matrimonial award.
And if the Court of Appeal was not minded to set aside the Zwarte Band's charge, did you advance any other argument this July in the Court of Appeal as to why, if the charge was to be left in place, the sale should be postponed?
Well, as our understanding of how execution of judgments operates, is that there are two stages. There is the stage of the registration of the charge, and then there is the stage of the summons for sale. And at the time that the court is exercising her discretion to order the sale, she can consider whether there are extraordinary circumstances in which she could indeed postpone the sale indefinitely, especially in the circumstances where it seems that she was defeating her own order by blinding herself to the danger into which she had thrown the matrimonial home, and at the same time ordering that the matrimonial home would be preserved for the occupation of the wife, who was a housewife after she was evicted from the business. And even when she was a participant in the business, she divided her time between looking after 3 young children and a home. So that in the judge ordering that the wife would have the occupation of the matrimonial home until the youngest child, who is now 13, completed her full-time education, which is itself a vague phrase. Let us assume that full-time education comes to age 18, or at least when one has finished one's A-levels. So that would then put us a further 7 years down the line from now, because that child is still in primary school. So that it seems to me that the learned trial judge, by preempting herself in making the order for sale, then got into a terrible difficulty when it came to her award and awarding the very property that she had ordered sold to be occupied by the mother and the children. And these are infant children. And this is all against the backdrop that as we address the Court of Appeal, and as we now address you, my lords, this husband has never paid a single cent and is owing hundreds of thousands of dollars in maintenance. So these were the reasons why we were asking the court to give the real estate to the wife and leave the husband with his very lucrative business. And we say, therefore, that what could the learned trial judge have possibly meant in suggesting that she was giving time to the parties to see what they could have done with respect to the property prior to, between the period when she gave a decision and when the order for sale would take effect, where it would have been very clear to her that this husband had absolutely no intention of settling this debt, and the wife had no means to settle the debt. And this is in circumstances where, presumably, he could have settled the debt. He could have entered into arrangements with the judgment creditors, who were his suppliers of tires in the business, by paying something on the debt. If it is that he's so prosperous, and if it is that he's lying in saying that he's living out of his car, and if it is that he's lying in saying that he's passed this business over to his brother and is indeed making a lot of money, at the inception of this matter, the husband made off with £80,000, which was the subject of an application for an avoidance of disposition that was simply ignored by the learned trial judge. So anyway, that's an aside. So now, be that as it may, and were I to persuade the learned trial judge, my lords and ladies, at the very least, that the order for sale was made in error, what then, how then are we to look at, I have invited you, my lords, ladies, to quite boldly to make a declaration that the order for sale was wrong. I point out that the order for sale was made in the proceedings which are before this court, and that order, yes, my lord, Wilson.
Mrs. Seabury-Sweet, you object to the order for sale. We understand that.
Yes.
Whether we can do anything about it is a matter that we will have to consider. But I don't think you challenge the fact that the companies have a charge on the husband's interest I don't think you take issue with the effect of Section 5 of the Remedy of Creditors Act. Is that right?
I am coming to that, my lord.
Very well.
Having regard to the first part of my lord's proposition, I do concede that on the face of it, subject to the argument which I will now bring, that there is a charge. There is a charge, but there is not yet a sale. There is an order for sale. And what we say is that the making of the order, that on the making of the order for sale, the court should have considered whether there were extraordinary circumstances that should have prevented her from exercising a discretion to order that sale. And I come to the case of, let me refer you to the case of Hegarty. The case of Hegarty, which segues me directly into my second argument, because I intend to cast some doubt on whether property that is owned, that the interest of persons,
Hegarty, I believe,
480,
is at page 482.
Is page 482.
Let's find it.
Yes.
Thank you.
Yes, so, my lords, my lords will see, if we look at the certificate of title, which is a document which is on the record, the certificate of title itself came before the court as part of the report on title. Let me find the certificate of title is at page 57 of the record.
Yes.
So one will see that the property is owned by the husband and wife in fee simple as joint tenants.
57.
Reuben Kanhai and Glenda Kanhai are now seized of an estate in fee simple as joint tenants in the lands hereunder described, Sangre Grande lands. So clearly, title is as joint tenants. Now, the case of Hegarty is a case which suggests that prior to the introduction in the United Kingdom in 1979 of the Charging Orders Act, that the interest of joint tenants in land was not properly classifiable as an interest in land, because at law prior to 1979, what parties who were joint tenants owned was an interest in the proceeds of sale, as holding as joint tenants meant that they were trustees for sale, and all they had was an interest in the proceeds of sale, and the joint tenants could not be said, therefore, to have an interest in land such that the Remedies of Creditors Act could attach to a joint tenancy. So I am making a submission that in respect of properties held on a joint tenancy in old law, as we have in Trinidad and Tobago, and as pertained prior to 1979 in the United Kingdom, it was not possible to sell lands held in a joint tenancy on a summons for sale, because there was no interest in land. And so let me quickly refer you to the case of Hegarty for this submission. In the head note of Hegarty, In 1978, a husband and wife purchased a house, and in 1979, the property was charged for a second time, actually, by the husband who fraudulently procured the second charge. In 1980, the second borrower brought an action, and in 1981, a charging order was made. But the wife only filed for a divorce after the charging order had been made in March of 1981. So the parties had been married for a long time. The husband was a police officer, I believe, a policeman, I believe. And so they purchased the house many years into their marriage. He ran off to live in Ireland. The wife went into the home. Just before that, he forged a debt agreement, forged his signature, and ran off. And then the lender proceeded against the wife. And what was held in this case is that what the wife was seeking to do was to have the very juxtaposition of her matrimonial proceedings with the civil proceedings. That was not acceded to. However, it was acceded to in the instant case. And what was held in this particular case on page 851 is that dismissing the appeal of the wife, who was appealing not the summons for sale, but the charging order, so that the matter had not as yet reached to the stage where there would need to be an adjudication as to whether there had been any extraordinary circumstances that would obviate or prevent a sale. What this case did was to say in the holding on page 483 as follows. The judge, in exercising his discretion under Section 1 of the Charging Orders Act 1979, had considered all of the relevant circumstances. And since the plaintiffs had been diligent in seeking the order against the interest in the property of the absent husband, and before the wife began her proceedings for divorce, there were no grounds for varying the judge's exercise of the discretion to make the charging order. So at this stage in the case, they were just at the stage of the registration of the charge. And you will see, my lords, that Lord Justice Stevenson said that the court should not use its powers under Part 2 of the Matrimonial Proceedings and Property Act to override the claims of a creditor, etc. It can and often should postpone the enforcement of a charging order until the hearing of any application under Section 30 of the Law of Property Act, which is the summons for sale, when the court could decide between the competing claims of the wife and the creditor. But here, the court was asked either to allow or dismiss the appeal. So this is a case where the creditor, the wife, was seeking to throw out the charge at the stage of the registration of the charge. And what the court effect of the judgment was to postpone consideration of whether the property would be sold to the time when it would come up on the summons for sale. But the part of the dictum that I would like to refer the court. Yes, my lord. Yes.
Is there a difference between a creditor who's got a charge and a creditor who wants a charge?
Yes. Yes, there is. But even there is a difference, but there is also a difference between a creditor who has a charge and a creditor who has not yet obtained a summons for sale. So what we say is you may very well be entitled to your charge, but when it comes to the question of the sale of the property, in my submission, there is a test. And the test is whether extraordinary circumstances exist. Now, the burden of the cases is that the ordinary situation of debt, and this is the case of Citro, which is also in the bundle. I'll come to it in a moment. There is a very broad policy, may I say, that runs across the cases, at least the cases of this vintage, that the commercial interests seem to take precedent over the interests of a wife and infant children. Now, that has been tweaked somewhat in the United Kingdom. It has not as yet been tweaked in Trinidad, but nevertheless, times have also moved on in Trinidad, and attitudes and mores have also moved on in Trinidad, notwithstanding that we have not had the concomitant legislation. However, the point I'm making is that whilst the burden of the cases that deal with debt attaching to property of husband and wife has been that the mere fact of the loss of property through debt is not an extraordinary circumstance so as to defeat the right of the commercial house. In our submission, in the instant case, there are extraordinary circumstances which fall to be considered on the proper hearing of a summons for sale, and that opportunity was not afforded or that discretion was exercised in the opposite way. So now, and I have attempted to draw to the attention of the court a case of Moss versus, which is a case which I sought very late yesterday to bring to the attention of my lords. Look at here, in my book. Did my lords by any chance get hold of that case? It's a case of it's a case of Abbey International PLC versus Moss and others. Yes, my lord.
Sweet. At the moment, one or two of us don't have copies of that case. So we're going to try to make good that deficiency. So hold the horses for half a minute, will you?
Very well.
Thank you. Yes, Mr. Baharel, can you help us? Well, that's for Sir Rupert.
Do you have another?
Can we share a copy?
Is this Abbey and Moss?
Yeah.
I've got it, yes. Yeah. Here it is.
Thank you very much.
Oh, Rupert's got it, so we can share, or I can make two.
Thank you. Yes, Miss. Have you got another copy?
I've got another one. It's marked.
That would be,
is that all right?
That
It's
would
marked.
be even better.
I'm so sorry. Please ignore the markings.
Definitely.
No, I'm just going to get it on.
All right, so
on Lexis.
Mary, have you got this? Well, then, you must have it.
Yes,
Mary, you've got it. Jill, have you?
No,
we've had it emailed to
what I
us.
have. Oh, that's right.
It came in a late email. I can
You had
ping
seen
it to
it.
you if you like.
I've got it.
We'll wait for later.
Yeah, I've got it. Thanks. Thanks.
Have you got it?
Yes, I have. Thank you.
Good. We've got it. Please
right.
proceed.
So I cite the case of Abbey National versus Moss for an instance in which the courts found, I beg your pardon, that there was an extraordinary circumstance that would permit them to dispense with an order for sale, or indeed postpone an order for sale indefinitely. Now, in the case, and admittedly, it is not on similar facts as our case, but I will subsequently attempt to show the court the circumstances in this case, which in my submission amount to extraordinary circumstances. But
Which in your submission amount to what?
Extraordinary circumstances.
Very well.
That would cause a court not to order a sale.
Thank you.
So in the case of Moss, a mother gifted a property to her daughter with a proviso that the daughter should not dispose of the property during the life of the mother. The daughter then proceeded to give a charge of the property to a bank, who it is presumed would have taken with notice of the, as let me call it, the fetter on the power of the daughter to dispose of the property during the life of the mother. And in this case, the court found that the commercial house could not take a security which was better than what was provided to them by their debtor, which was a property that could not be sold until the death of her mother. And these were circumstances in which they declined to order a sale. They considered these to be extraordinary circumstances. Now, in the case that I was referring you to of Hegarty, if I could get back to the Hegarty at page 486, and if I could read in the judgment of Lord Bingham, which was subsequently confirmed by Lord Justice Cross, I believe. But anyway, so
Are we back in the case of Hegarty now?
Yes, my lord.
Very well.
On page 486 of the record.
Yes.
And I will read from the top of the page, page 486.
Yes.
And this is the case of the police officer who had purchased the property and then gone off to Ireland, left his wife in the house. So in this case, what is said is from line B: since the wife did not execute the legal charge to the plaintiffs, she incurred no liability under that instrument either. It does, however, seem to me that the instrument may nonetheless have had two effects. If the husband and wife were up to then equitable as well as legal joint owners of the house, I think that this disposition by the husband was a sufficient act of alienation to sever the beneficial joint tenancy and convert the husband and wife into tenants in common. Now, in the instant case, we have no disposition by the husband. It's just that he has fallen prey to alleged debt. In any case, the disposition was, in my view, effective to create a valid equitable charge in favor of the plaintiffs of the husband's beneficial interest in the house. The second of these propositions is inconsistent with the decision of the Court of Appeal in Cedar Holdings Limited, which in Glyn's Bank was held to have been wrongly decided. And I think that the House of Lords would have accordingly have accepted both the propositions I've stated as being correct. Formally, and this is what I wish to direct my lords, ladies to, formally, the court could not have made an order charging the husband's beneficial interest in the house because the relevant statutory provisions related to interests in land and the beneficial interest in the proceeds of sale of land held under a trust for sale was not an interest in land. And then I have myself examined the case of Irani Finance Limited versus Singh, which I did not have the opportunity.
Mrs. Sieber and Sweet.
Yes, my lord.
Are we dealing with beneficial interests here or also legal interests?
We are dealing with legal interests.
Weren't they joint tenants in law?
What we are saying is that parties who own a property as joint tenants have no legal interest in land.
But that was
what they have.
In England, excuse me, but that was, in England, that was because of the 1925 legislation.
That was because of the 1925, which we still have in Trinidad.
Well, can I finish my question?
In Trinidad.
Can I finish my question? The statutory arrangements about which Lord Bingham is here talking, as I understand it, are those imposed in 1925, as a result of which, since then, all co-ownership interests in land have taken effect as an interest in proceeds of sale under a trust for sale. But I understand that's not the position in Trinidad and Tobago. as I understand it, but please correct me if I'm wrong, the interest of a co-owner in land in Trinidad and Tobago is an interest in land because the trust for sale is not automatically imposed by the 1925 legislation.
Well,
Am I wrong about that?
1925, the Conveyancing and Law of Property Act, Trinidad and Tobago, does not address that at all. It makes no mention whatsoever of joint tenancies. What it does say in Section 3 is that the law of property in Trinidad and Tobago is to be governed in all respects by the law in the United Kingdom. This is Section 3 of the Conveyancing and Law of Property Act, because I myself am not a conveyancer. I am a virgin, I'm innocent, let me put it this way, of this area of the law, except to having had to address my mind to this point. But I do recall in the recesses of my mind as a younger practitioner.
Is this point in your case for the respondent, Mrs. Seaburn-Sweet?
No, my lord, it is not. It is not in my case.
Very well.
It is not in my case.
Okay. Now, where are we? You've made the point. You've made the point. Time is getting on. Maybe you've got other points you want to press on us.
Well, the main thrust of my submission is that my main thrust is that the proper time to appeal the order for sale, by our understanding and by what should be considered to be a reasonable standing of all that had transpired, would be when the learned trial judge addressed it in her decision. And we were aghast that having made an order for sale, postponed, suspended, or however it is characterized, that this would have entirely been, as it were, considered to be an issue that was strange to her decision, that this was that she attempted in her judgment to divorce herself, as it were, from any responsibility from she herself having previously made this premature summons for sale, and then found herself making these extraordinary statements to the effect that the question of the debt of parties is not a consideration under what we call in Trinidad the Section 27 factors, and we say that she in acting precipitately in that manner, but why did she therefore take steps in her order to postpone the order for sale, if not that she meant to revisit this issue in her judgment? So therefore we were aghast that in her judgment, the question of her order for sale was, as it were, cast aside as if it had not been made, and then she went on to make provision for the matrimonial home and these children as if they would be entitled to live in the home which she herself had made vulnerable to this order for sale. And so that is why with alacrity we appealed. We appealed within a fortnight and approached the Court of Appeal for a stay of any sale of the property in whatever proceedings. And then we did in fact obtain an order for an expedited appeal. It just so happens that in Trinidad and Tobago, that expedited appeal took 4 years to come on because we simply could not get a transcript. We could not, the matter came up on the cause list 3 or 4 times. And Mrs. Perriman-Pollard made a nuisance of herself in the Court of Appeal registry, attempting to get a transcript of the proceedings. And the transcript was, when forthcoming, was missing large chunks and all sorts of, But the upshot of the matter was that we attempted with alacrity to prosecute this appeal. I mean, my lords will have seen the lengths to which we as attorneys for this wife have gone. Indeed, I neglected to mention that she is in court this morning. And I don't know if it is possible for you to see her, but she is to our right here. But I mean...
I think she was sitting two to your right. I think
She was
you've got
sitting to
Mrs.
my right
Perriman
when
Pollard,
allowed to speak.
and then
Yes.
we saw a lady and we thought that's probably the wife.
That was the wife. That is
Very
the
well.
wife, my lord.
Now,
So-
where are we, Mrs. Sieber and Sweet?
Yes, so what we say is that we are praying in aid the Judicial Committee of the Privy Council to find that had it exercised a discretion on whether extraordinary circumstances existed here, what we say is that the extraordinary circumstance that would have persuaded a right-thinking tribunal to postpone an order for sale were not circumstances of death, but circumstances in which a trial judge had actually ordered that the property be preserved after making an award for the occupation of the wife and children. So that to me is the extraordinary circumstance which takes this out of the ordinary situation of debt, which prior to the 1979 Act, the policy seemed to say that, look, if you're a commercial house, you have precedence, you have standing, your rights prevail over all else, even the rights of the family. That situation has been relaxed somewhat with the Charging Order Act of 1979 in the United Kingdom. But we say that, that with respect to the Moss case, that is an example of an extraordinary circumstance. And we say that specifically the extraordinary circumstance in this case is that here, the awarding judge, the learned trial judge herself, has actually identified that in the scheme of things, the house is to be preserved for the occupation of the wife and children. And we say that on appeal, that is likely, because we have every confidence in the strength of our appeal on those grounds, that in the face of the findings as to the credibility and the behavior, the litigation misconduct, the financial misconduct, the dispositions that were avoided, that were made by the husband contrary to Section 44 of the Act, that it was entirely wrong for a judge, after having made those findings of fact against this type of husband, to have then put her to the trauma of the impossibility of attempting to value a business for which there were no records by the admission of his own accountant, and in respect of which he had all the records, he had control. She could not, there would have been no material to have handed to an accountant, which would usually be annual financials, to value that business. So it would have been wrong for the learned trial judge, was wrong for her to have said, I'm splitting everything down the middle. In our submission, the appropriate order for her to have made was give the wife the real estate and leave the husband to his devices with the business and the debts. And we say that had she made her adjudication on the summons for sale at the appropriate time, she would not have twisted herself into these corners that she did in her judgment by, on the one hand, saying she had no choice in ordering the sale of the property, when she was specifically given the choice to be exercised at the time when she was considering the award. That is the vice in the current situation, the making of that summons for sale when it was made. And so we are praying in aid the Judicial Committee of the Privy Council to frown upon that order for sale and all that has flowed from it, and to bear in mind that the appeal which the committee has before it is an appeal in the civil proceedings, and it is an appeal against a decision of the full court that the property not be sold until the final award to the wife. There is absolutely nothing wrong, inconsistent, unfair, abhorrent about that relief that was granted by the Court of Appeal. And all we are asking the Privy Council to do is to confirm that prohibition on the sale of the matrimonial home until the Court of Appeal has made its final decision. The court is free to make a very narrow decision along those lines. We invite the court to pronounce on the unwisdom. Indeed, I would wish that the court would have the power to set aside that order for sale. But
well, Mrs. Sieber and Sweet,
yes,
you've made your points very, very eloquently and forcefully. I suspect that you're nearing the end of your submissions.
I am, my lords. Unless there is anything else that I can help with, I am looking to Mrs. Perryman-Pollard to see if I've left out anything. My lords are so well in possession of all of the facts. What I would ask the court to do, if I may take the liberty of so doing, would be to look at that Irani Finance Limited versus Singh decision that was made, that was referred to in the Hegarty case, and I would submit ultimately that in Trinidad and Tobago, the joint tenancy does not create an interest in land, so that so that the registration of a judgment attaches to a joint tenancy.
Sir
Yes,
Rupert has a question for you.
Yes.
I could not hear one thing you said. What is the statute, section 3 of which says English law applies?
The Conveyancing and Law of Property Act, the Conveyancing and Law of Property Act, Chapter 5601, Ordinance number 18 of 1939, which was significantly amended in 1981, but none of those amendments have come into force, modernizing the law. So Section 3 of the Conveyancing and Law of Property Act says that Trinidad and Tobago is governed by the law of England. And I have searched the Conveyancing and Law of Property Act up and down, and I see no reference whatsoever to joint tenancies.
Thank you.
So my submission is that in Trinidad and Tobago, we follow the old English law that a joint tenancy does not create an interest in land so that a charge can attach to it, but rather merely that a joint tenant holds. Yes, my lords.
Lord Briggs has a question for you.
Ms.
Yes.
Sieber and Sweet, it's said against you that this property, if it were sold, would have sufficient value to have enabled your client to acquire another place to live with for herself and her children out of her half share of it. I haven't seen anything in the materials which you've put forward, or for example in the grounds of appeal, which challenge that, although I have read your assertion both in the grounds of appeal and what you've said to us, that if the sale were to go ahead, it would make the judge's order nugatory. Yes. Is there anything in the materials which challenges the assertion made against you that your client's half share is sufficiently valuable to enable her to find for herself and her children somewhere else to live?
Well, let me start off by saying, my lord, that my friend has provided no evidence to support his assertion that 1/2 of the value of the matrimonial home would be sufficient to provide her for a home to the standard of living to which she and the children were accustomed during the marriage, which is one of the factors, you know, there have been challenges to white and white in Trinidad and Tobago, but that part of the white and white judgment, which says that there must be a fairer balancing of the Section 27 factors, such that the standard of living is not completely ignored and thrown under the bus. We say that if you look at the totality of the assets, a very lucrative business, impossible to value by virtue of the husband's control and his lack of record keeping and his general financial misconduct, and 2 items of real estate. We are not only seeking the matrimonial home, we challenge that $2 million is sufficient to provide the wife with a home suitable for herself and 3 growing children to the standard enjoyed in the marriage. She would then have to look for some sort of townhouse somewhere, and this is a very nice property. So we say that giving her, in terms of her housing need, $2 million is not in accord with a proper balancing of the Section 27 factors. And we say that, and this is what we've said in our notice of appeal, the order that we're seeking is that she obtain the 2 properties because this lady and her children are unlikely for the future to derive any periodical payments of any sort for the husband. He has been in blatant contempt of all orders, and the learned trial judge was unable to deal with him. Indeed, why she gave him a hearing under the Hodkinson principle, it is difficult to understand at all why she gave him a hearing at all in the ancillary relief proceedings. He was in contempt. He had not filed his affidavit of financial evidence, and she made all of the findings of his misconduct, his non-disclosure, and so on. So that for the future, all this lady and her children would have to depend on is real estate. They would not get any periodical payments.
Any more questions?
No, thank you. Thank you very much.
Any questions, no? Mrs. Sieber and Sweet?
Yes, my lord.
Thank you. I want to address Mrs. Perryman Pollard, please.
Yes.
Mrs. Perryman Pollard, obviously you have contributed a very great deal to the preparation of the defense of this appeal, and the board is really grateful to you. Is there anything that you want to add orally?
No, please, my lord, I don't.
Thank you very much indeed. Mr. Baharilal, what do you want to say by way of an economical reply?
I shall be very economical. To answer the board's question in relation to the Conveyancing and Law of Property Act, Chapter 5601, I'm only going to touch on the very beginning, but I think it's important that the board has it. It does make provision that a deed is to have the same effect on questions arising thereon as to be decided in England. That's the margin note, but the opening words are, every deed made after the 10th of June 1844 shall be taken to have the same effect as would be the same by the law of England in force on the 1st of April 1858. So I'm not going to read the whole thing out, but I think it needs to be looked at in context.
Thank you.
I'm sorry, are you saying therefore it does not bring in the 1925 legislation?
It doesn't appear to bring in the 1925 Act because that happened much, much later.
Yes.
But it's the type of proviso that the old ordinances included to deal with any lacuna as at that time. But plainly, there have been other pieces of legislation since. My Lord, in relation to the, and it's a brief response, I was asked the question about powers to grant a stay in the Court of Appeal. It's Part 64 of the Civil Procedure Rules, and I cannot find any other provision beyond the ones that I have drawn to the board's attention that deal with stays of execution. I hope that answers my Lord Briggs' earlier question. In relation to the consolidation point that has been raised by Mrs. Seabrand-Sweet, could I invite the board's attention to page 153 of the record. I don't think it can be seriously disputed there was no consolidation. This is why the appellants had to make an application to be heard in the family proceedings. And page 153 and page... I give you, your lordships and my ladies, just that reference because they're both the same for both appellants. They're in identical terms, but this is the one for Zwarte Band. Just dealing with the effect of the orders. In relation to the suggestion, just bear with me for a moment. Sorry, yes, I'm very grateful. Page 130, the order for sale. Exactly the same for both appellants. It's paragraphs 7, 8 and 9. The issue in relation to a prospective purchaser, as far as the order for sale was concerned, the registrar has the conduct of the sale. The property can be put up for sale, and then any monies that come from the sale are then lodged with the court to the credit of the defendants.
Mr. Baharilal, can I ask you a question
Yes, of course.
about paragraph 7,
Yes.
which says that the money arising out of the sale shall be paid in towards the satisfaction of the said sums due to the claimant by the defendants,
Yes.
plural. What sum was owing by the wife to your clients?
In relation to these two appellants, my lord, she successfully set aside the judgments in default, so there is no money owing from the wife to the appellants in this appeal.
Well, then why does it say defendants, plural?
We would accept, and we would say that that doesn't refer to Mrs. Kanhai, but that must refer to Mr. Kanhai.
Oh. Well, there we are.
Because this is only an order in relation to the two companies,
Very well.
the other defendants. And perhaps dealing with that particular point in relation to what has been said about the timing of both proceedings, could I invite the board's attention to page 359 of the record? I know my Lord Sir Rupert is using a different copy of the judgment of Ram Kerry Singh. It's paragraph 30, if that helps.
Yes?
And this is the judge's consideration of the civil proceedings. And then if you turn over the page, just in terms of the chronology that the board has just been addressed on, the judge notes that the trial in the family proceedings had been completed 4 days before the hearings of the summons for sale. That is on the 13th of March. And so the judge had well in mind both the representations and evidence in the family proceedings prior to making the orders for sale, which of course were made on the 17th of March, and the hearing for the summons for sale, where all parties were heard and present 13th of March. Paragraph 31, again, the points in relation to what has been considered and the errors of Madam Justice Ram Kerry Singh. We say this at great fairness to Justice Ram Kerry Singh. She did say she was balancing the interests of the civil and matrimonial parties, considered balancing, exercising fairness and justice for all of them was a first for her. So certainly she's indicating this hadn't arisen in something she dealt with before. But what she does go on to say is that she was bound to consider the liabilities of the party before her, but not to work into the civil judgments or other debts unconnected to the matrimonial proceedings, and then expressed her concern that to do so would have put the creditor's claims on the matrimonial property above Mrs. Kanhai's, that's the respondent's, financial relief, and wouldn't have been fair to her and her children. And we underscore with that, my lords, that, of course...
You're dropping your voice, Mr.
Sorry.
Harriler.
Forgive me,
It's
I'm
got to
leaning
be heard
forward.
a long way away.
Yes, I appreciate that. In relation to this particular paragraph, it really just was to highlight that in answer to the point made about how the judge dealt with the proceedings, she did take it into account, whatever orders she subsequently made. In relation to the other property that has been mentioned by my learned friend, can I direct the board's attention to paragraph 25 of the judge's judgment? And this is why the appellants have expressed concern about to what extent the respondent and Mr. Kanhai may have cooperated, because 4 years was a very long time for this appeal to come on. But what the judge found in relation to this only other property is that this had been conveyed, it seems, before the marriage broke down, and the judge has upheld that conveyance in this part of her judgment. So we don't actually have, as far as the appellants are concerned, a basis to go after that property. I'm so sorry.
Mr. Baharilal, Mrs. Seaburn-Sweet wants to raise something. We'll let her do so now. Yes.
Thank you, my lords. There was no conveyance of the second parcel. There was merely an oral agreement for sale, which had been, to put it at the highest for the husband, of which there had been specific performance, because the brother of the husband had been put into possession. But as we speak, there is no deed transferring property to the brother of the husband.
Thank you for clarifying that. You heard that, Mr. Baharilal?
Yes.
I really don't think that we need to get into the detail
not
of
at
the
all.
other property.
It's quite all right. It's simply to highlight this reference to the appellant's ability to attach to other properties. It's not available. And then, can I take the board, please, to the point that has been made about when the debts arose, responsibility, etc. We don't have a judgment. I've conceded that. But if I could invite the board's attention to page 12 of the record, the particulars of claim, they're identical for both parties. The debts with which we are concerned go back to 2003, to when the claim was issued. It's paragraph 1, paragraph 4, and paragraph 5, when the correspondence began.
I'm not sure that's right, because for the first period, they were paying the debt satisfactorily.
They were paid. There were monies being paid. That's absolutely right. But the period over which these debts appear to have arisen predate, which is the short point, the 2009 date, which has been paid in aid in this case. That's as we understand it. But of course, I've not seen all of the evidence that was filed in the family proceedings, but I don't take it any further. It's,
Were we concerned with any date prior to the registration?
no, not for the purposes of the appellant's appeal. I accept that. Yes. My Lord, I hope I don't need to address it in any detail, but as far as setting aside the order for sale is concerned, I don't think the board has the power to do that. We would certainly urge the board not to do that. There's been no cross appeal here. And in fact, there's still been no appeal against the orders for sale. It would be an extraordinary situation for the board to deal with something that hadn't even been appealed to the Court of Appeal. And I've addressed the board on that already. My Lord, in relation to section 26, it's a very short point, but insofar as it arises,
Section 26
of the Matrimonial Proceedings and Property Act.
Very well.
Could I just check that the board has received a single page? I see my Lady Black has it. It's a single page which will go into the authorities bundle after page 470. And although no party has relied on it, it was really because we had included section 27 as a whole, but for some reason it didn't get into the e-book. But now the board has
Well,
it.
I've already explained that my judicial assistant gave me parts of the Act which I felt I needed and which hadn't been provided.
No.
What does the extra page cover?
The extra page covers the completion of section 27, paragraphs G and H, because it ends in the board's bundle at paragraph F.
Yes.
So the board has that. And the short point in relation to 470, paragraph D at the top, an order extinguishing or reducing the interest of either of the parties to the marriage under such settlement, which one of the points that Mrs. Seaburn-Sweet raised. Quite apart from that being highly unlikely, what it attaches to is an existing interest. So it can vary an interest that is already in existence, but for the reasons we already gave, that cannot affect the registration of the judgment, which locks onto the beneficial interest as at the time of that judgment. It might attach to what is left, having taken into account the debts that the
Lord
parties
Briggs's
owe,
point.
and that's, yes. I'd like to say it was mine, but yes, Lord Briggs's point. My Lord, in relation to Hegarty, which my learned friend addressed you on, page 483. We had actually cited this before my Lord Wilson raised the question with me about whether it ought to have been remitted to the family division. I accept, of course, it was an option open to it, and in fact, I make not so much a concession, but make this observation to assist. The civil proceedings rules does provide for the transfer to the family division. So it's certainly a power that the court had under its case management powers, and insofar as it was exercised by the Court of Appeal and not challenged beyond that, it was open to the court to do that. But in relation to the dicta in this particular case, we also rely on Hegarty, page 483, and we say that although you can postpone the enforcement of a charging order, the reason I drew the board's attention to that paragraph which showed when the summons for sale was heard, it indicates that the judge had considered all of the evidence in the family case before she heard the summonses for sale, and so before she made the orders for sale that she did. And insofar as the court was required to take into account the liabilities or future liabilities of either of the respondent or Mr. Kanhai, she did so. Final point, in relation to the filing of the petition, which predated the filing of the claims by the appellants. Although a factor that the courts may consider is when a particular claim was lodged, another factor we say that the court has to consider is how long the proceedings go on for and whether they've been prosecuted diligently. And the appellants are not able to say who was at fault, nor do we try. But the judge, before making the orders for sale, plainly had regard to both when the proceedings were filed, but also the disproportionate length of those proceedings. So even though the petition for the property settlement was lodged before the claim of the appellants, that is but one factor, we say, that the court should take into account before they made the orders for sale. And particularly here where there'd been a long delay, we say the judge was entirely right to have made those orders. My Lord, I said I would be brief. I have been. Can I assist either my lords or my ladies with any other matter?
It seems not. Thank you very much, Mr. Baharilal. Rereading section 26 on granting a decree of divorce. I'm not sure we've been given the date of the divorce, either nisi or absolute. You won't know what the date is, but Mrs. Sieber and Sweet will.
Yes,
yes.
Find it in the judgment. I'll give way to Mrs. Sieber and Sweet.
Mrs. Sieber and Sweet, dates of decree nisi
Yes,
and absolute, please.
Petition, the petition was filed by the husband in, what's the date of the petition? The petition was filed by the husband, my lords, on the 12th of November 2010, and the wife filed her ancillary relief application on the 4th of December 2011, but it had, you sure that's correct? 4th of December 2011. The ancillary relief application was filed the 4th of April. 4th of April, I beg your pardon, my lords, 2011.
So can I just get this clear? The date of the decree nisi, please.
The date of the decree nisi, my lord, was the 25th of July, 2011.
25th of July when?
Which year?
25th of July, 2011, my lord.
2011. And it has been made absolute now.
Yes, it has been made absolute, my lord.
Thank you. Right, well, the board is extremely grateful for the advocates, those who spoke, and those who helped, and those who prepared. Often, in this new arrangement of receiving submissions by video link, there is a problem about hearing the advocates from Trinidad and Tobago. There was a problem initially. I am happy to say it was entirely sorted, and the result is, Mrs. Seaburn-Sweet, I want to tell you, we have heard every word that you uttered. And we must now go away and consider what you said and what Mr. Biharilal said, and we'll take time to consider our judgment. Thank you.
We are very grateful for my lords, my ladies' patience and forbearance with the technology.
Thank you very much indeed.